I'm going to talk to you about what's protected by copyright. Copyright comes into existence when something that's capable of being protected by copyright is fixed in a tangible medium of expression. It basically means something gets written down or filmed or painted or created in some way that someone else can perceive it. In other words, pretty much anything that's not still stuck in your head. So what's protectable by copyright? First of all, music is protected by copyright. Both the sound recordings, and there could be multiple owners of sound recordings, plus the people who wrote the music, the people who wrote the lyrics. Pretty much anyone who creates something to go into a sound recording gets at least one part of a copyright. Additionally, plays are protected by copyright. Interestingly, choreography can be protected by copyright, but remember, something has to be fixed in a tangible medium of expression. So if you don't want people copying your choreography, you should either use choreographic notation, or since not that many people know how to do that, you can just film it. Then it's been fixed. Other things that are protected by copyright include writings. So if you write a book, you write a journal article, an abstract to a journal article, a newspaper article. An email is protected by copyright, although I'm not aware of anyone actually asserting copyright against someone who's making copies of their emails. Certainly, it's not going to change people from forwarding it around. What about tweets? Interesting area. I think technically tweets are protected by copyright, although again, I don't think you can really do much to enforce your copyright in your tweet. Be an interesting situation. Architecture is protected by copyright, although as you can imagine there's a whole series of rules, especially designed to prevent someone from being sued for infringement when they take a picture of a building in plain sight in the middle of a city. Software is protected by copyright, and of course video games and the music in the video games. Starting to get the idea that the more complex a work, particularly in audiovisual work, is there might be many, many different copyrights. So in addition to full-length motion pictures, when you take a Vine and post it, or when you post a video on YouTube, you've got a copyright in those. Assuming, of course, you created those yourself. Of course, artistic works are protected by copyright. So whether it's a painting or a drawing, it's protected. Sculpture is protected. Photography is protected. And if you take a photograph of a three-dimensional object, like a sculpture, that's protected by copyright. What if you take a picture of a two-dimensional work, like a painting? Typically, if the goal of taking that picture is to make a really great reproduction of that painting, then you don't have copyright in it. As much skill as it takes, you're not adding creativity, and that's the line. What isn't protected by copyright? Ideas are not protected. Data in and of itself is not protected. Inventions are protected by patents, not copyright. And logos are not protected by copyright. Always seems on TV programs they mix that one up. But nonetheless, a logo is protected by trademark law. Now, where it gets really interesting is if you've got a really great artwork, which is used as a logo, it doesn't lose its copyright protection just because you use it as a trademark. But as a general rule, trademarks are not protected by copyright.